The Lucy Letby case has ignited a firestorm of controversy, divided opinions and raised profound questions about the justice system. While some firmly believe in her innocence, others are convinced of her guilt. This case has sent shockwaves around the world, sparking debates about the fairness of her trial and the potential for a miscarriage of justice. And that's what we're going to look at today. But before we make a start, and for the viewers who are unfamiliar with the case, Lucy Letby, a neonatal nurse in the UK, was found guilty of murder and attempted murder of several infants in her care. The issue that we're looking at specifically here today is what happens when the prosecution presents expert evidence and the defence does not. This is a question that's been gnawing at me for some time, and I recently stumbled on this thought-provoking article on the Law and Policy blog website. This video draws heavily on the insights from the article, and you'll find the link below to it in the description. The question that we're going to address today is, did Lucy Letby receive a fair trial? To answer this fundamental question, we need to examine the key differences between the prosecution and the defence case. The prosecution relied heavily on expert testimony to support their case. The defence did not offer any expert evidence. This disparity significantly influenced the jury's deliberations and ultimately their verdict. By not presenting expert evidence, the defence significantly limited the jury's ability to comprehensively evaluate the case. Without opposing expert viewpoints, the jury was unable to weigh the evidence and arguments against each other. That is, they could not compare and contrast the expert testimony because there was none present from the defence. This imbalance in the presentation of evidence tilted the scales of justice in favour of the prosecution, allowing their expert testimony to exert undue influence on the verdict against Letby. Before exploring potential reasons why the defence may not be at fault here, let's briefly review the roles of the expert witness, the prosecution, and the defence. In a murder case such as this, the prosecution and the defence present opposing theories to explain the crime, in this case, the murder and the attempted murders. The theories guide their arguments and evidence. The prosecution's job is to prove the defendant's guilt beyond a reasonable doubt. The defence aims to raise doubts about the prosecution's case. This involves challenging the prosecution's expert evidence to raise reasonable doubts in the jury's mind. The defence might question the expert's methods, identifying potential flaws or biases in their analysis. This could also involve challenging their techniques, data sources, or even the assumptions they make. Expert evidence is absolutely crucial in a criminal trial because it offers specialised knowledge to help establish the facts. Now, I want you to consider this question. Who does the expert witness owe a duty to? Is it the prosecution who employed them? The answer might surprise you. Expert witnesses have a duty to the court, not to the prosecution, even though in this case, the prosecution paid for the expert testimony. Expert witnesses must provide their opinions honestly and impartially, relying solely on their expertise and the evidence they present. They should be unaffected by personal beliefs, financial incentives, such as getting paid, or pressure from the other side of the case, in this case, the defence. Given this duty, the decision by the Letby defence team to forego expert evidence raises significant questions. But unfortunately, we don't know why they made that decision. Only Lucy Letby and her defence team know the answer. What we do know is that Lucy Letby is satisfied with their work. Otherwise, she would not have relied on them for subsequent appeals. Remember, it's Lucy Letby, not her defence team, that makes the final decision. They may provide advice, but it's Lucy Letby who has the ultimate authority as to what happens during the trial. This then begs the question, why would Lucy Letby and her defence team decide not to call expert evidence? The Law and Policy blog highlights 3 distinct reasons why the defence may have chosen not to call their own expert witness. The first potential reason for the defence making a decision not to call an expert witness could be financial. While it's possible that Lucy Letby may not have had the potential funds to hire an expert witness, it's likely that legal aid would have been available to assist her. The second reason comes from Adam King, an experienced criminal barrister. And this is what he said. One reason the defence might have chosen not to call Dr. Hall, and I'm speculating here, is if they felt they had so thoroughly undermined Dr. Evans that they were better off leaving it that. That would be a big tactical call, but covering your own back is not always consistent with protecting your client's interest. He goes on to say, so, for example, if your expert would contradict much but not all of the Crown's expert conclusions, and you believe the credibility of the Crown's expert has been totally destroyed, you might judge it prudent not to put your own expert in the witness box, avoiding the potential for future criticism and hindsight regret by putting your client in what you believe will be a worse position by calling your own expert. This is all speculation, but I guarantee that careful thought went into the decision not to call Dr. Hall. None of this, though, would mean that the conviction is safe. What Adam King is suggesting here is that the defence might have believed they had effectively undermined or even discredited Dr. Evans during their cross-examination. Their thinking may have been that it was safer to leave things as they were rather than taking the risk of further damaging Lucy Letby's defence by calling an expert witness, which avoids putting Lucy Letby in a worse situation. These types of decisions are made all the time by defence teams. They would have carefully thought about the implications of not having their own expert on the stand. The third and final reason for the defence's decision may lie in the relatively newness or uncertain nature of the medical knowledge involved in the Lucy Letby case. For instance, research into neonatal embolisms may have been limited, making expert testimony potentially risky. The defence may have feared that their own expert witness could have inadvertently provided evidence that may have been used against Letby during cross-examination. In such cases, calling for expert evidence can be a strategic gamble, as it could potentially contradict or weaken Letby's position. What is known is that Letby's defence team made very strong oral arguments. They argued that the prosecution lacked sufficient evidence and therefore the prosecution's expert testimony should have been dismissed entirely. Considering this, the expert evidence in this trial could have significantly weakened the defence's ability to challenge the prosecution's case. While we don't know the exact reasons behind the defence's decisions, they likely had legitimate motives. So who's at fault here? Calling an expert witness can be a strategic gamble. It could have potentially strengthened Letby's case, but it also carried risks on the other side. The expert's testimony could have been challenged or discredited during cross-examination, potentially weakening Letby's position. In this case, the defence may have made a strategic decision to highlight the potential weaknesses in the prosecution's expert evidence. However, it's important to note that the defence's questions during cross-examination do not constitute evidence, and the jury must make their decision based on the presented evidence, not the defence's questioning. The prosecution must ensure their expert evidence is reliable. If it's not, it may mislead the court. Moreover, it's not the defence's job to fix the prosecution's problem. It's for the prosecution to ensure their expert evidence is reliable. The Law and Policy blog rightly points out that this is more of a systems error rather than a problem with either the defence or prosecution. Although having said that, of course, the prosecution's expert evidence must be reliable. And this is one of the many issues that the third wall inquiry will have to grapple with. The legal system should be equipped with mechanisms to address situations like in the Lucy Letby case. and this would prevent similar occurrences in the future and ensure that justice is served. Did Lucy Letby receive a fair trial? That's questionable. I'll let you make up your own mind. Leave a comment below and share your thoughts. I always appreciate hearing back from you. And if you found this video informative or thought-provoking, give it the thumbs up and subscribe. Your likes help us reach more viewers. Until next time, take care.